Good morning, everyone. Thank you for joining us on behalf of the Constitutional Rights Center of the Supreme Court of Justice of Mexico and the Law School of the Leiden University, in particular, the program on the rights of children and young people. We want to welcome you to this new session of this cycle on access to justice for children in practice, in conformity with the optional protocol to the Convention on the Rights of the Child on Communication Procedure, the OP3. We are really pleased to receive today two great colleagues, friends, activists, and academicians from this world of the rights of children and human rights in general. And we're here to discuss a particular approach that so far in previous sessions we have been approaching just like on a superficial level, but we think it is essential so we can really understand what it means to have access to justice, not only for boys and girls, but with them. So for that purpose, we want to focus this session on the role of children in these strategic litigation processes and litigation in general, in the field of constitutional rights and internally and also internationally on different platforms for the protection of human rights that will allow us at the same time reflect on the participation of children in the exercise of these mechanisms for individual and collective complaints before the Committee of the Children's Rights, which is actually a matter that hasn't been discussed that much in the framework of the implementation of this protocol. So we want to welcome our guests on behalf of the Constitutional Rights Center of Mexico Supreme Court and the Law School of Leiden. We coordinated this with Tom Liefaard, who's joining me from the other side of the Atlantic in today's session. I'm going to introduce, well, the structure of the session is going to be first by Aoife Nolan from Nottingham University, and then Karabo, the director of the Center for Child Law in South Africa. I'm going to introduce Professor Nolan and then Tom Liefaard. Once it's time for Karabo's presentation, he will give a proper introduction. Professor Aoife Nolan is a professor of international human rights law and co-director of the Human Rights Law Center at the University of Nottingham in the UK. Her professional experience has focused on human rights and constitutional law, both in the different legal, policy, practitioner, and academic aspects. She is currently vice president of the Council of Europe's European Committee of Social Rights, which she joined back in 2017. She has published extensively in the areas of human rights, constitutional law, and particularly in everything related to the economic and social rights, as well as children's rights. She currently, and she will be talking about this in today's session, because she leads a major international research project called Advancing Child Rights Strategic Litigation. She has acted as well as an expert advisor in several international and national organizations, including different UN special procedures, treaty bodies, and other organizations. She has also been a visiting professor in Europe, Africa, the US, Australia, as well as many other roles. It is a pleasure for me to present today Aoife. So without any further ado, Aoife, you have the floor.
Well, thank you so much for that, Nicolás, and thank you to Tom and to the other organizers of this event. It's a huge pleasure to be here. I know that this series of events has been very successful and very interactive and has really been very thought-provoking. So it's a privilege and a pleasure to be here. So let me start by putting my technical skills to the test by trying to share my slides. Excellent, for once I can find them. And here we go. So today I'm, to some extent, it's a particular pleasure to speak to you today because for the last 18 months, I have been involved in a global research collaboration called Advancing Child Rights Strategic Litigation. And this is an 8-partner project. Karabo, who is also speaking, is a partner in the project, as are a number of people that I think I can see in the chat who will be joining us later on. And what's interesting about the project is that it has brought together the theory and the practice of child rights strategic litigation. And the reason why I think it's particularly relevant to this series of events is that so much that the introduction of the optional protocol, the third optional protocol to the CRC, providing for this individual complaints mechanism, has really driven forward interest in and practice in the area of child rights strategic litigation. However, while lots is being done in the area, there's actually very little research in the space. And of course, your concern, it isn't enough for us to say, oh, well, this is all happening. It's fantastic. It's inevitably good for children's access to justice. What we want to do with the project is to consider how this work can really be leveraged and shaped to maximize the opportunities to advance and to push forward children's enjoyment of their rights, including in the context of work directed towards the third optional protocol complaints mechanism. So what do we see happening? In the last 20 years, we have seen child rights being an increasing focus of litigators, with actors bringing, with an ever-increasing number of actors and a greater range of actors bringing cases in different legal contexts, okay? Child rights strategic litigation, we in the project understand as being litigation that seeks to bring about positive legal and social change in terms of children's enjoyment of their rights. So we are very much focused on litigation that is designed deliberately to push forward children's rights enjoyment, either through legal change and or through social change as a result of engaging with the courts. Now, what we're doing with our project, the work that does exist in the area of child rights strategic litigation, whether it's research or whether it's advocacy related work, an awful lot of this work has focused on how child rights strategic litigation can be most effective in terms of pushing children's rights forward externally, right? And by that, I mean that when we look at, say, work around child rights strategic litigation, whether by practitioners or by advocates, child rights have primarily played an outward-facing role, okay? They've been treated by practitioners and others involved in planning and implementing strategic litigation as a schema or a framework that should constrain or mandate the actions of external decision makers that are the targets of strategic litigation. So when we see this work being done, it's very much from the perspective that children's rights are of huge importance, but strategic litigation work has been very much focused on getting external duty bearers to make sure that their actions are consistent with child rights, okay? And what we as a project are interested in looking at, and this ties in very much with the issue of access to justice project, is we are very interested in child rights as a lens to be turned inwards by those carrying out child rights strategic litigation. So to look at their own practice and to consider the extent to which their practice in how it's carried out, right? Not just what it aims to do, not just what it does in terms of impact, but actually how child rights strategic litigation is done. To what extent is that practice consistent with child rights standards? So it's using children's rights as a lens to turn inwards rather than something that is simply for other people, for the targets of litigation. And I should be clear that our aim with the project is not for a second to sit back and say, oh, litigators, they're doing a terrible job. My goodness me. We are very conscious that those carrying out child rights strategic litigation are under huge pressure, working very much from a perspective of good faith, and that they face very serious constraints in terms of both capacity and funding when it comes to their work. So our aim with the project is to turn a critical eye, but also to create tools to support people carrying out strategic litigation, to help them to make sure that their work is not just good in terms of what it seeks to do with children's rights in terms of the people it targets, but also in terms of how it's carried out. And so we are, very much, our work is very much, we're very much tied in with the work of practitioners. We have a network. We are designing tools, we're designing reports and resources. So I want to give a sense of the context, because for those of you at this meeting who are interested in the area of child rights strategic litigation, I think it's important to emphasize that this isn't just a dry academic project where we sit around in workshops. It's very much aimed at supporting people who are carrying out this really important work. Okay. So why are we seeing this increase in child rights strategic litigation, right? We've seen an explosion in the last 20 years, and particularly in the last decade. And first of all, we see this growing profile of children's rights, okay? Child rights is a hot topic, both in terms of international human rights law and in domestic human rights law advocacy and litigation work, right? And we're seeing, as the profile of child rights goes up in terms of national and international understanding and practice, we're also seeing an increasing understanding of the particular issues that children face as a group. Okay, there's a growing consciousness, not just of the CRC as a set of standards or domestic constitutional provisions as a set of standards. There has been growing understanding over the last, particularly in the last, I would say 5-6 years, internationally, about the characteristics of children as a social group and the challenges that children face, okay, in terms of their rights. And that has very much shaped planning and thinking around strategic litigation. There's also the fact, another reason that we're seeing an increase in child rights strategic litigation is because, frankly, it opens up legal argumentation opportunities that other areas of human rights don't. Okay, children have child-specific, group-specific rights protections that other groups don't have. So if you're looking at children, you will often be able to make an argument relying on a broader range of rights than you might be able to do so with other groups. And of course, again, it's not just about legal argumentation opportunities. There's also the fact that children, sometimes incorrectly, are perceived as a group that are likely to, invoke public sympathy or support as a social group. The idea is that, for instance, if you're dealing with perhaps a highly fraught or a contested area, that children are in fact more likely to invoke support or concern or attention with regards to a particular issue than other, shall we say, less socially popular groups will do. So there's a sense of that. There's a feeling on certain parts of litigation. I've heard litigators say, oh, well, we like to get children into our cases because obviously everyone likes children and the courts like children. I'm not sure if the practice shows the courts always like children, but certainly that is a motivation that we're seeing on the part of some litigators. The other thing is, and this is entirely admirable and very much consistent with concern about, the child's right to express their views and, freedom of expression and children's agency, we're really seeing litigators in the last few years wanting to support and to advance the agenda of children themselves, right? So we can think of this really as the catalyzing effect of the optional protocol. As well, we can think of this as being the catalyzing effect of the CRC, this growing understanding that it's not just litigation about children, or litigation about children cannot be litigation without children, to paraphrase the language of the disability rights movement. And finally, of course, there's the motivation for this set of events. We have the catalyzing effect of the third optional protocol. This has absolutely focused the mind of a range of different litigators, including litigators who would not necessarily have been child rights litigators historically. Okay, so we're seeing a change. We're also seeing, we're seeing changes in terms of who is interested in children's rights. Okay, and a broadening in the number of people doing the work. So I think we're at a stage where to be honest, we're looking at a situation where we have real challenges and opportunities for child rights consistent, child rights strategic litigation practice. Okay, so some of the challenges, right, when we think about child rights strategic, when we think about whether litigators are framing their work around children's rights principles. Well, first of all, litigators carrying out child rights strategic litigation more and more are not necessarily human rights specialists. They might be disability specialists, education specialists, environmental specialists, but they aren't necessarily children's rights practitioners. And the other thing is, not only may they not have a specialism or familiarity with regards to children's rights standards, but they may not be used to working with children. And I think Karabo's presentation will be very important, because here you're hearing from someone who has really deep experience of working with children in a range of different contexts and in a range of different ways. But that is not common experience on the part of litigators, of many litigators, even those who are very interested in carrying out child rights strategic litigation. There's other challenges. If we think about child rights consistent child rights strategic litigation, it can be, if we think about some of the key elements, and I'll come back and I'll talk a little bit more about the rights that we're talking about framing it. But if we think about one of the areas that we have talked about and that Nicolás has already raised, that we already know is an issue, child participation in the context of litigation, there's obviously challenges posed to child participation and child agency and child decision-making in the context of litigation by the highly technical nature of some child rights strategic litigation argumentation. Okay, and I'm thinking of climate justice, for instance, though it's certainly not alone being like this, but where you have extremely dense and challenging, evidence, as well as, different legal standards pulling in from a range of different sources of law. That is challenging when we think about how to maximize the extent to which children's views should guide litigation practice that relates to those children's rights. And of course, the other thing when it comes to CRSL practice is the fact that we see very strong we see the same issues with regards to representation of children in this context as we see in other contexts, okay? And we see, particularly, in addition, we have obviously lawyer-child relationship. There's always the adult-child power differential, okay? You can try to minimize it, but certainly we have yet to come across anyone doing litigation in this space who does not acknowledge that there is always, to some degree, a power difference between the adult and the child involved. But there's also power differentials that are exacerbated by things like race or ethnicity or class or gender or disability. Okay, so all of these things come into play when we think about the challenges of giving effect to children's rights when carrying out our practice. But then there's also fantastic opportunities, right? And I want to just start with, we've carried out interviews with a wide range of litigators at this point, and it has been extremely impressive, first of all, to see the extent to which litigators have really pushed to make their own work consistent with child rights practice. And even where they haven't done so, there is a real enthusiasm or desire to do so. So there is clearly a nascent but growing understanding that children's rights are something that should be taken into account in practice. And that's very significant. Okay, where we have come across, for instance, in our interviews and our network events and our engagements, we really have felt we're pushing on an open door. Okay. There's also another thing that's extremely positive in terms of, pushing forward child rights strategic litigation practice is the existence of very strong child or youth movements. Okay, which means that in some areas, we're really seeing children driving and being true collaborators in the context of litigation. And I think we'll come back to that in Karabo's presentation, and I will talk a bit more about that in the end, where we're really seeing where there's an alignment of litigation with youth movements. We're seeing we're seeing that power reduced, and we're seeing genuine partnership and collaboration. And the other major opportunity, of course, is that strategic litigation of child's rights particularly in some areas, not in all, but in some areas, there's very good funding. And this funding can also is also available for capacity building. So for practitioners who want to ensure their work is consistent with child rights, there is perhaps more work, there is more funding available for this than there is for capacity building in other areas. Okay, that's a sweeping generalization. I know that it's not true of all litigators, but it's certainly something we've come across, that there's a feeling, for instance, again, I use climate justice because it's such a hot topic, but there's actually quite a bit of money at the moment, and that some of that money can be leveraged for capacity building. So I'm conscious, oh, my screen has just frozen. Okay, I think I might just skip this. So I think, you might turn around and say, well, why are we looking at this issue? Why are we even considering the question of child rights or child rights compliant practice? Why should we be looking at lawyers and others to carrying out this work? Because the fact is the UN Committee on the Rights of the Child doesn't mention lawyers, right? I think there's a reference to legal assistance in the context of provisions around juvenile justice, but there is no major discussion with lawyers. And also, and that contrasts, say, with references to parents and legal guardians and their rights and responsibilities under the convention. There's nothing like that for lawyers. The other thing is, if we look at the work of the Committee on the Rights of the Child, and I'm talking about general comments here because they are ultimately the most authoritative outputs, authoritative interpretations of the CRC, and this issue hasn't been dealt with in detail in the OP3 complaints decisions yet. When the committee has talked about children, litigation and lawyers, it has tended to focus primarily on the fact that children should be provided with free quality legal assistance. And they focused a bit on what that representation or that assistance should look like. And they've talked about training, right? They haven't focused that on the specific responsibilities and duties of lawyers or CRSL practitioners, right? When the committee has talked about strategic litigation, and it has only done so as far as we can see in 2 of its general comments, it has talked about public interest litigation, which is a term that is used synonymously in many instances with strategic litigation. And it has said states should make this kind of litigation possible as part of remedies, access to remedies. So we're not seeing the committee engage. The one place where we do see the committee really showing evidence of or real interest in child rights strategic litigation is in the context of its general comment 2 on national human rights institutions, where the committee really stresses that national human rights institutions should be empowered to and should carry out, should bring cases before the courts to advance children's rights and should bring third-party interventions and amicus curiae. So the committee is clearly aware this work is being done, but thus far there has been limited engagement directly with the responsibilities of those carrying out this work, okay? But there's obviously, for those of us who are working in the space, we're obviously conscious that just because it isn't mentioned expressly in the convention, and just because the committee hasn't addressed it directly, doesn't mean that the convention and its rights do not have implications for children, child rights strategic litigation. So for instance, and I just want to pull us back to a really important statement of the Committee on the Rights of the Child in General Comment 5, where they say implementation is an obligation for states parties, right? So first and foremost, the CRC implementation is for states, but implementation needs to engage all sectors of society. And the committee recognizes that responsibilities, so not duties, but responsibilities to respect and ensure the rights of children extend in practice beyond the state and state-controlled services and institutions, okay? To include a range of actors, right? And it's an open list. And clearly, if you read that, it is something that can be applied to CRSL practice. So it's something to just be very aware of, that it is clearly, while it is not explicitly foreshadowed in the committee's work, it is clearly implicitly addressed. You know, there's clearly scope to use that work as the basis for arguing for this child rights perspective. And indeed, I think it's very helpful to look at one of the very rare situations where we have seen a professional body or indeed someone working specifically on CRSL practice to think about how children's rights should shape practice. And there's an excellent set of resources from the Canadian Bar Association on rendering your practice with children more child rights compliant. And I think the statement from them: in every action a legal professional takes affecting a child, that professional has an opportunity to respect the child's rights and uphold the child's well-being. And I think that that's really significant. It's the point is, it's not that we're saying the CRC requires you to do this legally. It clearly doesn't, right? You know, it's hard. It would be very hard to make that argument based on the text and based on the Statements Committee. But what is very clear and very correct is that there is an expectation of response. There's a responsibility to respect and ensure, but there is also an understanding that professionals, when they carry out their work, have an opportunity to do this work in a child rights compliant way. And that is the very strong feeling. That is the attitude that we would advance in our work. So what does it mean? What do I mean when I say child rights strategic litigation? Now, I just want to check, when I do that, does that disappear on your screen? Has it gone off presentation for you? Nicolás, can you still see the slides full screen, or has it gone to still full screen? No, it's gone smaller. Okay. Well, then I need to very quickly, do something here. Excuse everyone. Just let me do this quickly. Otherwise I cannot access my notes, which is going to be problematic. Sorry about this, everyone, but otherwise there's a risk that I'll speak for 35 minutes and I don't think for 45 minutes, and I don't think anyone wants that. So what we have here is we have identified a series of the rights in the CRC that we think have the greatest implications, or the clearest implications for child rights consistent CRSL practice. Okay, so we have, for instance, Article 12, the right of the child to express their views and those rights to be given due weight. We have the right to freedom of expression, to information, evolving capacities, non-discrimination, best interests, survival and development. I mean, right to protection from abuse, neglect, negligent treatment, right to protection from exploitation, and also, of course, the duty to take all appropriate measures to promote recovery and social reintegration of victims. Okay. Now, you may well look at that and go, well, that's lovely. How nice that you've identified those rights, but what the heck does that mean in practice? You know, what does this mean for me as a practitioner or someone who's interested in doing research in this area? So what I want to flag, and I'm just going to quickly do, before I give you examples of what this means in practice, I want to flag that these rights should inform all stages of child rights strategic litigation, right? So that includes the scoping, the planning and the design of strategic litigation, the operationalization of strategic litigation, the follow-up to litigation, including implementation and broader dissemination, you know, sharing the outcomes of the litigation, and extra legal advocacy and media work. Okay, so these are the four key areas that we have thought about how children, where we have looked and where we have thought how they should be shaped by child rights standards. So let me give you an example, right? Let's go back to our rights. Let me see if I can skip back here without making everything explode. Article 12, right of children to express their views. This, for instance, if we think about the design of litigation, children should be involved to the extent that they can be. Obviously, there are newborn babies and other children who might not be able to be involved. To the extent that they can be, children should be involved in identifying the rights issues to be litigated in child rights strategic litigation. They should be involved in defining the goals to be pursued by the litigation and the broader strategy of which the litigation forms part. Okay, and their views should shape that and be given due weight. And very importantly, when it comes to Article 12 and children being able to express their views, it's crucial throughout the lifetime and beyond of the litigation that lawyers and others working with children must engage with and effectively communicate with children. Okay, so it's not just about saying, this is what we're doing, we'll see you when the case is over, right? It's about ongoing updating and communication with children. And we see some fantastic practice around this, the use of social media in really innovative, child-friendly ways. In a way, you know, this is an area where there's really positive examples of where lawyers, even when they haven't explicitly used children's rights as a standard for their work, they have in fact been carrying out child rights consistent strategic litigation practice because they've been doing the right thing in their work. Very importantly, when it comes to Article 12, children's views, strategic litigation must not co-opt or undermine children's policy or advocacy agendas, right? It's very, very important that children's agendas are not undermined by strategic litigation. And this has been a big debate in strategic litigation work more generally, this idea that litigation can effectively undermine social mobilization and political advocacy. And it's arguably even more of a case with regards to children, where access to democratic decision-making processes is more complicated than for other groups. And finally, with Article 12, and this is very tricky, is children must be supported to call a halt to litigation whenever they wish to. And this is hard, okay? This is very tricky because there are times when we'll want to keep things going, but the fact is if children express that view, then it has to be given effect to. Let's think a little bit about the right to freedom of expression, where media forms part of the litigation strategy. Children have to be provided with the support needed to engage with the media effectively. So for instance, we see examples such as the Tiger case, which was supported by Just for Kids in the United Kingdom, where children who were involved were provided with media training and very careful support. These were children whose migration status affected their access to education funding. And there was real possibility for negative media coverage, but they were supported very carefully by their lawyers and other experts to manage this effectively for them. And furthermore, another thing about children's right to freedom of expression is that children's views about how they or their cases should be presented to external audiences, including when publicity materials, has to be given effect to. And that applies to, frankly, work that's also done by collaborators or funders. It's not just about lawyers doing the right thing, it's about the people, others involved in the advocacy or others supporting the advocacy. 17, right to information. There's a lot of work on this in the context of child-friendly justice. Children have to have the information necessary to understand the opportunities and risks involved in litigation, and children have to be kept aware of subsequent developments following the judgment or, final decision. So it's all of it is, most of you who are lawyers are sitting there going, well, this is kind of basic good practice with clients. It's true, but our argument is that the CRC provides a coherent, integrated framework to be applied in a way that's helpful, and it makes it a good resource for lawyers. Crucially, Article 5, evolving capacities. And this is the notion that, as children's capacities evolve, the extent to which parents and others, legal guardians, provide them with guidance or, shall we say, supplement their decision-making decreases. And I think one of the things we see with child rights strategic litigation is it can go on for a very long time. And as litigation goes on and children's capacities evolve, lawyers' reliance on parents' views on how children's rights should be secured must shift towards greater reliance on children's understandings of how their rights can best be ensured. Okay, so it's about changing. There might be a balance, a change in the relationships through the course of it. Article 2, non-discrimination. Obviously, it's very important that child rights strategic litigation doesn't discriminate, litigators don't discriminate in terms of selection of appropriate clients or in terms of the balance that they strike between the interests of different clients, okay? So think about, that's potentially tricky because when it comes to standing, client selection is a delicate process, right? So it's tempting to go with the easy client, but the question is, does that raise issues of discrimination or inequality in terms of practice? We can come back to that. Article 3.1, best interests. We have in all litigation, children's best interests must be a primary consideration. And that applies to all stages. Again, client selection. And again, if a child wants to finish the litigation. And it's not, what's important here is that it's about a really careful weighing up of best interests. Okay. And it's very difficult. I mean, there may be a bigger case that could be brought, or more exciting, more expansive case. But ultimately, when we think about lawyers' obligations to their clients, those are not trumped by the best interests of other children. And again, it's a delicate balancing exercise and one we think through. The right to survival and development might seem like a surprising thing to focus on here. And don't worry, Nicolás, I'm coming to the end. It might seem like a surprising thing to focus here, but actually involvement in strategic litigation for children is not cost-free, okay? So decisions with regards to bringing litigation and how it's carried out, or extra legal advocacy like media work, it mustn't impact negatively on children's survival and development, okay? So for instance, educational or psychological toll or harm caused by litigation must be recognized and mitigated, right? Litigation is enormously demanding, right, for children. It's emotionally demanding, psychologically demanding, and frankly, if it takes enough time, it can affect educational demanding. And some of what we've seen with litigators is how they balance engaging with their clients and their clients' educational needs and their exams, etc., etc. I mean, Articles 19, 36 and 39, I mean, it's fairly straightforward. Children mustn't be exposed to harm or re-trauma as the result of the litigation process. So for instance, that's a real potential issue in cases around sexual violence or immigration, for instance. Strategic litigation must not exploit or instrumentalize children. And this is a real issue when we think about how we've seen this increased trend towards child rights strategic litigation work. But to what extent is that work in fact? Sometimes the questions are asked and can be asked and should be asked about whether in fact that litigation is ultimately exploitative of children. Another thing related to this is there has to be extremely careful management of children's expectations, okay? Children can be absolutely devastated. A loss is devastating, but where children's expectations are not managed, it's particularly devastating, especially if there's a situation where there may not necessarily be life experience that helps them to contextualize that loss or that failure of expectation. And finally, with regards to 1936 and 39, children mustn't again be exposed to harmful media attention. And that's something that just have to be borne in mind. So this is just some of how the rights standards might work in practice, how they arise at different stages or different decision-making points in strategic litigation. I want to finish with a few very quick thoughts, right? And don't worry, I really am finishing, Nicolás. First of all, there's a lot of talk at the moment about child or youth-led child rights strategic litigation. It's really important to interrogate claims about that. That is a big claim. What do we mean by led? Do we mean collaboration? Do we mean a situation where litigation is, giving effect to a children's broader policy agenda? What do we mean here? But it's a term that's bandied about too often, and we need to think about it. For people carrying out the work, for practitioners, they need to be prepared to start small. There's no shame in starting small. It is whenever we build our capacity in an area, we don't leap in at the deep end, right? Start with small things and move towards the big ones, okay? Tweak your practice and then, and grow your practice along with your ambition. Very important that if we're thinking about child rights, consistent strategic litigation practice, it must look beyond best interests and participation. These are not the only relevant rights, okay? And I've spoken at length about the other rights that might be taken into account, but child rights lawyers, but particularly people who aren't child rights experts, tend to become focused on best interest and participation. And actually, we need to be looking in a much broader way. And finally, and this is something I think that's worth thinking about in the context of the optional protocol, is that often cases that are brought to the optional protocol or complaints are the result of interactions or collaborations between international and local partners. And you can have a situation where international partners are absolutely enthused about child rights consistent practice and have very careful standards themselves in how they do their work, but they're not in fact engaging with their local partners to ensure that the same standards are being applied at the domestic level or by the local partners. And that leads to potential risks in terms of the overall child rights consistency of a complaint, where there's a disconnect between maybe what the international partner does or the local partner does. And of course, it could be the other way around as well, where you have very good practice at the domestic level in the local partner, but not at the international level. So these are all complexities where you have multi-level or transnational collaborations. I leave it there, but I'd really welcome questions.
Thank you very much, Aoife. Perdón.
Thank you, Aoife, for your presentation. It's so complete, and hopefully we'll have time for comments in the end. And Tom Liefaard is going to give the following introduction.
Thank you very much, Nicolás. Good morning, good afternoon, good evening. Greetings from Leiden University. It's a wonderful opportunity again, and thank you for joining us today. Maybe it's your first time in this webinar series, maybe it is your fourth time. Welcome to everyone. It is my great pleasure to introduce to you our second speaker of today's webinar, and her name is Karabo Ozah. She's from South Africa, and she's currently the director of the Center for Child Law at the University of Pretoria. She's also a lecturer at the Department of Private Law of that same university. But leading the Center for Child Law means that she is the director of a very important child rights organization, promoting and protecting children's rights through advocacy research, but above all through strategic litigation, today's topic. It's fair to say that the Center for Child Law is renowned for its strategic litigation efforts, and it has worked on that for more than 20 years. Karabo has also led and contributed to the work at the center before she took office as the director, and she has been involved in, you could say, litigation successes, not only in the South African Constitutional Court, but also in the lower courts, including high courts and the Supreme Court of Appeal. And Karabo is also a member of the advisory committee of the South African Law Reform Commission's project 100D on care of and contact with children. And she is a member of the Hague Expert Group on international parentage and surrogacy, connected to the Hague Conference on private international law. Karabo, it's absolutely wonderful to have you with us today, and I would like to give you the floor.
So in practice, there are a number of barriers that prevent children from accessing education. I think for this group of learners that we're dealing with in the Fochville case, the two main barriers were the issue of distance and the issue of language in terms of accessing high school education.
In the little town of Fochville, there was a lack of schools, a lack of places in schools, and the township schools were all full to the brim.
For these learners, it appeared as if there wasn't a school closer to where they lived. So the nearest English medium school that they could go to was in Carltonville, which is about 25 kilometers from Fochville. But there was an Afrikaans medium school that was closer to them, that was not full and had space and could actually take them in. The only thing was the fact that it was an Afrikaans medium school and they wanted to be taught in English. But the Department of Education nonetheless informed the learners that they should apply to that Afrikaans medium school.
The school governing body pushed back against this and said no, their language policy said Afrikaans. They didn't mind taking black learners, but they had to learn in Afrikaans. And so they said the children should go to Carltonville. But Carltonville was some 25 kilometers away, which would mean the children would spend a lot of time on the bus. And many of them actually lived within walking distance from the Fochville Hoërskool.
It's unfair for the small town children to travel a long distance. I mean, children wake up very early, and you even get small children for primary schools that have to wake up early to go to a school in Carltonville, which is very far. There is already a school that's only accommodating a specific group, which is only Afrikaans children, which is unfair for us, the English kids.
There was a lot on the shoulders of these children because they were actually in this quite alien environment.
My experience from the school was bad from the first day because I was registered in the Afrikaans class, and then by then I didn't know Afrikaans like properly.
We were coming from primary. In primary we were taught in English.
And then the principal said, no, if I can't speak Afrikaans, I have to go to another school.
What we wanted them to be mutual to us, like having a mutual language which all we can understand.
They were not welcome. They could feel that.
The kids actually treated us differently and we were bullied. We were called names like die swart golf.
We were told that we may not speak English in the school, basically by the children. This is an African school. We have to apply to the language in that school.
After the school governing body launched a case against the government and the government started limbering up to defend that action, the Centre for Child Law, represented by the Legal Resources Centre, got involved in the case. And we drove out to Fochville and met with the children. And we said that it was important, we thought, for any court to hear firsthand from the children what they were experiencing.
They were able to speak on our behalf. We were able to express our emotions and feelings.
I was glad because we were informed of what was really happening.
The way that we had approached the case then was to put that before the court, to put their experiences before the court.
Now we captured all of this information in questionnaires, responses to questionnaires, which the children themselves filled in. We told them, don't worry, this is to inform what we're going to tell the court, but we won't be giving these questionnaires over. The school governing body took a very dim view of this and said that we were making allegations of racism and that they needed the questionnaires in order to see what were the real allegations. And we said, no, it's not necessary.
And at the hearing of the matter, senior counsel for the school made it very clear that what they wanted to do was to take each questionnaire, analyze the handwriting, match it to a child, and then question the child about the things that they said.
So I was scared that if the principal finds out that I wrote on the paper negative things, that she might do something negative towards me.
We decided to hold firm and we refused to hand over the questionnaires, and we applied for leave to appeal. Now, our case ended up in the Supreme Court of Appeal, and there we won. So there the court made a lot of the fact that it was important to hear from the children.
The judgment strengthened the right of children to participate in matters that affect them and to be heard. But more importantly, also to protect their dignity by not unnecessarily revealing their identity when you're representing them. I think it was very important in this case to ensure that children's names remain protected.
It's the first time we got a really good comprehensive judgment from a higher court, higher than just the High Court, a provincial High Court, to give us a judgment on why children could be legally represented.
The main court case dealing with the placement of the learners in the Hoërskool of Fochville was settled through the Department of Education coming to an agreement with Hoërskool Fochville that the 38 learners will remain in the school until they finish their grade 12, but that there will not be a new intake of English-speaking learners, and the department was planning to build an English medium school in Fochville.
They kind of fought their battle by using us.
There had to be a case for us so that a school could be built.
On a huge scale, I think it's really bad because now it remains an African-speaking school.
We are the last group actually to go there.
And we even thought that school was built for us.
Yes.
And we had to find out
the first matrix.
Yes, and they told us no.
We were unlucky about the whole situation and everything.
There will never be another English class. Everything will be back to normal. So I think we're the first and the last.
We were hoping that the case would pioneer dual medium schools, in particular in small towns like Fochville, where in the country we have quite a number of small towns where you still have single medium Afrikaans schools. And we were hoping that through making schools dual mediums, one will be promoting inclusiveness and starting to do away with the segregation on account of race and language. What the case did do is it confirmed the importance of the right of children to participate in matters that affect them directly and to be heard. And that is very important because we never had such a judgment from a Supreme Court of Appeal. It also did strengthen the access to education by ensuring that particularly these 38 learners were accessing education close to where they live and in a language that they preferred, which is English. So, doing away with what we had identified as the barriers to education.
It was calming me down, the fact that I have a lawyer, the fact that I know there's someone else fighting for me, whether they're going to win or not. They made me stay at school.
It was like we had a voice in the school.
Thank you so much. I'm going to just share my screen now. Thank you. Good morning to most of the people. It's evening on our side. Thank you so much for this great opportunity to be part of the webinar on such an important topic. I think Aoife already set a good ground for the challenges in relation to when you're legally representing children and you're doing it the right way. And I think our video kind of also shows the reality of it and the things that we had to battle with. Just a few disclaimers. So the learners agreed that we can use the video. They're no longer in school, obviously, a few years ago that we recorded it. In relation to them telling the story, we also made sure that they tell the story once they were finished with high school. So they were no longer part of the school because we were going to put it on media platforms, and they had issues pertaining to whether they would be exposed. So again, one has to always look at your practices when you're dealing with children and how you protect them, not only immediately, but beyond the litigation. Can I move the slides myself? Can everybody hear me still?
Yeah, we can hear you, and you have the control over the PowerPoint.
But it's not moving from my end. I apologize for that.
It's okay. Maybe if you minimize it a little bit, and then you might be able to see the forward and backwards buttons. I don't know.
Yeah. Okay, let me try and do that. I'm gonna try and stop sharing first.
On the bottom left is where you have the chance to move backwards and forwards. If you can connect.
Oh, thank you. I sincerely apologize for that. So I'm sorry about that. I'm taking a minute to sort it out. So in South Africa, and I'm not going to read out all these slides to you because I'm mindful of time, and it would be great to engage with the participants. In South Africa, we have very strong provisions in relation to children being able to participate and be represented in matters that affect them, matters that are going to court. In particular, we have Section 15, which mirrors our constitutional provision, which is Article 30. But it's actually located in the Children's Act that clearly sets out that all the rights that adults have in relation to being able to bring or be assisted to bring matters to court also are applicable to children. when Aoife talked about strategic litigation, is that litigation can also be unpredictable. Ideally, when we do strategic litigation, you want to plan it, you want to, plan how you're going to involve children. But as you would have seen in this case, the case started without us, and we had to find a way to intervene in a manner that would still be able to advance the rights of children. We at that point had not anticipated that there would be such strong opposition to the children being part and setting out their views in front of the court. I think Aoife already touched on this issue about sometimes parents being the people who help assisting the children, but actually there are times where the interests of children and parents may differ. And maybe here is where I must tell you about the fact that in this case that you just saw the video, when we got involved in the case, the parents were already legally represented and obviously fighting the school's position. And when we got involved, we said, well, the children must also be heard. And we had to firstly talk to some of the parents who said, well, no, we're good with you legally representing the children. But later in the process of litigation, we had challenges where ourselves, as the legal representatives of the children and the legal representatives of the parents, actually had a fight about the fact that the legal representatives of the parents were putting quite a lot of information in the media. They were, wanting to do interviews about the case. And the children had told us that every time there's a report about the case in the media, when they get to school, they actually face some retribution. They are told that they're trying to garner sympathy with the whole country and that they're not welcome at the school still. So we actually had to iron out that issue so that the children could continue to be protected while they were at school. I think the background, the video kind of already gave it, so I'm gonna skip a bit. I think the slides might be shared with you guys. I want to mention the issue of how we actually ended up with the nice judgment, as you would have seen in the video. So we went and consulted with the children and took their information on questionnaires, and then came to the office, and one of our colleagues compiled an affidavit under oath setting out all the views of the children and how they felt, which some of the things were actually quite very sad, because all they wanted was to be in a school where they're welcome and study and not have to face being called names all the time. But when we got to the High Court, the lawyers of the school said that we need to give them those questionnaires, because the minute we explain the content of those questionnaires in our affidavit, we did away with the privilege, the attorney-client privilege. And I mention this because we must also remember when we're doing child rights strategic litigation that the rules that apply generally in relation to litigation apply also in relation to children. You don't get special rules, and if technicalities are raised against your case for children, you have to, mount the opposition in a way that protects your clients, and there are no special, processes for you. You will see that the Supreme Court said that there was a way of best interest to also protect children, but we had to squarely also oppose the issue of the fact that the school was alleging that we did away with privilege, or the children gave up their privilege when we put the information in the affidavit that we filed before the court. So we lost in the High Court. The High Court said that yes, you must give them the questionnaires, and we refused because the children were still in the school. We knew what they would face if they, as you would have seen my former colleague Karina explaining, the school wanted to come and interrogate them about, oh, you said we called you names, you said we did this to you, can you explain? So we were not prepared to have any of these learners go through that. And then we went on to the Supreme Court of Appeal. Again, here we have the provisions that are in our Children's Act. I've already mentioned Section 14 and 15. There's also a right to participate in Section 10 of the Children's Act. Our Constitution in Section 28(1)H also provides for legal representation. There are issues about, what that really entails and the different modes of legal representation. But over the years, we've kind of, at the Center for Child, written a bit of a guide as to how would you approach legal representation depending on the age and development of the child. We also made arguments in relation to Article 12, which a lot of you are familiar with. Being on the continent of Africa, we have the African Charter on the Rights and Welfare of the Child, which sometimes the provisions that are slightly stronger than the CRC. And in relation to this issue of children being able to participate in proceedings, you will see there that Article 4.2, clearly says that the child has a right to be heard in all judicial and administrative proceedings directly or through an impartial representative as a party to the proceedings. So we relied on those arguments. And we also said that revealing the questionnaires will not be in the best interest of the child, of the learners, and that they never did away with their or relinquished their privilege. Supreme Court of Appeal agreed with us, and actually, as we mentioned in the video, they said that the right of children to be heard and to participate, particularly in matters like this, where it has to do with their day-to-day real life situation, was very important. And that how you bring the matters before the court will depend obviously on the facts, and that it was clear in this case that the way we compiled our affidavit and did not reveal the details of the children, or it did not even have them joined as individual direct parties in the case, was to protect them. And the court found that the questionnaires were privileged. There's a whole bit about the technical aspect of privilege and what it means. And a lot of other people benefited from this interpretation from the judgment, because it not only applies to adults, but also, to children, but also to adults. And lastly, the court said that even if privilege may have been waived, it would not have been in the best interest of the children anyway to share the questionnaire. So reading all the interrelated rights of that were at play here. So what I wanted to kind of say is that what we've learned over the years is that
Karabo, we lost your audio.
Karabo, can I intervene? Karabo, can you hear us? It doesn't seem. It doesn't seem that she can hear us.
Maybe someone from the technology team could tell us what's going on. I think we all hear each other and everything's perfect, but we cannot hear what she's saying. I don't know, maybe we can send her a chat message. I will write to her.
Estamos haciendo algunos signos acá en la pantalla, a ver si me ve.
Maybe Nicolás, you would like to continue with the conversation and we'll get back to her. Well, I suggest that we'll try to reach her. Aoife Nolan, I don't know, maybe she has her number and she said that maybe she texted.
Yeah. I've tried and I've texted and tried ringing, so I guess her phone isn't within reach.
Karabo is really focused on what she's saying, so she's still talking. Can you hear us, Karabo?
Karabo, can you hear us? We cannot hear you. We have problems with your audio. Can you the chat?
Okay.
Can you hear me?
I can hear you now. I've turned off my headphones. Can you hear me now?
Okay, I think Karabo, we lost your audio like 5 minutes ago or something like that. Maybe your headphones they ran out of battery. We can hear you now. So if you can take out maybe your headphones, and we can get back to it. Sorry about that. We were trying to send you some messages, but you were concentrated properly.
I sincerely apologize about that. I think
we can hear you well now. So if you want to take it back, I think we lost you like two slides before where you were presenting. So maybe you can take it from there.
That's not so bad.
Sorry about that.
Karabo, we lost you when you said that the Supreme Court followed you.
Okay. Okay, I'm not going to project the slides if that's fine with you, because I'm getting towards the close. So they did confirm that the children had the right to participate, that the children had not waived their privilege, and that also it was not in the best interest of the children to actually reveal the details. Even if one was to find that they had waived their privilege, there was still the obligation to also consider their best interest. And given that they couldn't agree that the privilege had been waived, and made the order that the children, it's correct that the information was not shared. So that was kind of the end of the case. My next slide was just talking to the fact that when you're doing this kind of litigation, you always have to be careful. I think the case illustrates that the competing interests that we saw between the children and the parents, the fact that obviously, you know, you want access to justice and you want children to be heard, but you don't litigate in a vacuum, in a sense that the rules that apply to adults apply to children as well. You have to manage the expectations of children. And here I was mentioning the fact that you would have seen that there was a bit of sadness around the fact that they didn't get to go to the new school. They had to stay in that school. So in a way, they fought a battle for other people, but they didn't actually enjoy the fruits of that litigation. We, as a Center for Child Law, had a lot of learning from that case. It was the first time we actually sat and reflected with former clients to, assess what do they think about the approach. And I think from that, we learned that you actually have to always, and if I was mentioning this, take your clients with you and also be clear to them what is possible and what's not. And also that sometimes other factors control the litigation and you can't control all the factors. But in the end, I think we managed to have an outcome that they were saying that, at least their brothers and sisters, the younger ones, don't have to go far, even though they can't go to the World School for Will, they don't have to go to Carltonville, because through this case, a new English medium school was built. I just want to have further concluding remarks. Obviously the session said OP3 process. So you would have noted that I said in Africa, we have the African Charter on the Rights and Welfare of the Child, and it has an inbuilt mechanism. In a lot of cases, communications have already gone to that body. So on the continent now, there's a debate about why should we ratify OP3, because we already have the other mechanism. And I had myself and Professor Anne Skelton had to present to our International Relations Office minister to say these are the benefits, and that if you protecting children's rights holistically, you already ratified the convention. So ratifying OP3 is just an additional layer of protection. Obviously, they're scared about cases being taken to the committee, but they again remind people about having to exhaust domestic remedies, obviously, unless if there are exceptions that apply. And in South Africa, we're still lucky to have the highest court in the land being very favorable to child rights issues. So we are in the process of, South Africa is now considering ratifying OP3. They're still a bit ambivalent about, do they really need to, do they want so many bodies watching them? But the committee is already watching them because they report to the committee. And just a last parting shot is that obviously the regional and international treaty monitoring bodies are a great avenue to ensure access to justice for children when all else has failed. But we must lay the foundation locally and work properly with children locally and not rush to be seen to have all these international kind of cases without having done the proper procedures, because we're setting up children also for disappointments where you're going to get a case being thrown out at the CRC because of issues of not having exhausted domestic remedies and all those things. Yeah, so maybe let me end there. And apologies again about the technology failing me.
Thank you so much, Karabo. Thank you very much indeed. No need to apologize. These things happen, and it was nevertheless very interesting, starting with your video and also making that very important point that that the international level has something to offer, but you need to, of course, invest first and above all into your local remedies and how to make that work and how to include children there, and also to manage expectations, a point that you made very clearly, but also a point that was made earlier on by Professor Aoife Nolan. We are welcoming questions from everyone in the Q&As section in the Zoom channel, and we'll do our best to channel these questions to the speakers. Nicolás, I think you already had one of these questions ready, so if I could give you the floor.
Thank you, Tom. I have a question for both speakers. It's actually a two-sided question. Some people are asking, from what age, in particular, can children interact in the legal procedures with the court, but also from what age do you think that kids can become active in their own process, also for the design of the strategic litigation? That is one question that the audience is making for both speakers. And I would like to add something for Aoife. Based on all of these reflections on these litigation experiences, and it's two things that I want to ask you. First, I don't know if you observe a difference in the way that strategic litigation is understood between the North and the South, or between different political, cultural, social contexts. And I say this because there are certain practices in strategic litigation that are more traditional in some areas of the world. Some lawyers that basically litigate and include children. And there are other political or cultural contexts. For instance, in Chile, in the past 10 years, the children have become a political transforming force, and the lawyers sometimes are like staying behind and try to support them. But it's not what the lawyers have to do to consider the kids, it's rather the kids that are like one step ahead in the social transformations. They work faster than adults. So this gives a different dynamic of the lawyer-client dynamic and relationship. So I want to ask about these differences. I don't know if there's like a standard lawyer that has to consider like standard criteria, or are there political, social, cultural differences? And the other part of the question, what lessons in strategic litigation in general, not exclusively for children, but in the past 20 years, what do you think that could be important to consider for children litigation? For example, some structural changes, structural remedies. What are the limits of the strategic litigation for structural changes in countries when there are no like one or two issues where we have more like poverty and discrimination, violence, and the litigation may be different from countries that have progress and peace and equality. And also, I can see that there are different areas in the world, like Latin America, where there's a lot of skepticism on these constitutional litigation. Even if you work with children organizations, some lawyers are not related to children rights, and there's like some skepticism in some regions, and they think that perhaps this is not a good way to make progress. I don't know if it has permeated in children litigation so far.
Do you want us to tackle those questions, Nicolás? Okay, so I think maybe Karabo, do you mind if you start, because I think there's more for me, so it makes sense for me to go at the end. Is that all right?
Yeah, that's fine. So just as a quick point to reply to the question about age, I think the approach is that we don't put age as a barrier to children expressing their views. So obviously the modes would be different. And I mentioned that we developed a guide for attorneys and advocates in private practice to guide them. So there are cases where, like currently where at my center, we have 3 cases where we are curator ad litem's for children who are younger, because you can't get direct instructions for them, but you're still placing their views and weighing that up with their best interest for the court, and you file a report. And the older they get, you use your discretion. It's a very difficult job to actually decide whether they can directly give instructions. But once they're teens, they come. We've had 15-year-olds who've told us, I want to go back to court to say I don't want to see my father. I don't want to go there every weekend. And then we put that before the court, and you successfully get the court order. So age should not be used as a barrier to getting children to participate. We must be creative about the how. Some judges in South Africa, the judges when we started were very, very conservative. It's funny, we have a case now where a judge about 10 years ago gave us problems about representing an 11-year-old and 12-year-old. But this year, she appointed us to represent and give views of an 8-year-old. So she's transformed over the years. And that's what you do with this kind of work. You push boundaries. The important thing is obviously weighing up the risks in that particular case, but also weighing up, looking at if you have a child who's 9 years old and is persistent, I don't want this, I want this is my view, you're going to have to put that before the court. Obviously also having tried to explain to the child that I can't guarantee you that the court will go the way that you want. So age should not be used. We've had challenges where people question the fact that, oh, but they're too young, and we don't subscribe to that. Before I hand over to Aoife, I just want to quickly say that on the second issue that you asked, I mean, we must remember that countries are very conservative. One of the nice judgments that we have, not very recent, on the continent in relation to children being allowed to go to court was in Zimbabwe about child marriage. And there the case was interesting because it was the first time the Constitutional Court used the CRC to found standing. And standing is the biggest issue. If children don't have standing and they cannot bring cases, it doesn't matter how you want to help them, you have a problem. But in that case, the lawyers pushed the standing boundaries, and the Constitutional Court was ready to accept that, and it's come up with this nice judgment. And now a lot more people can represent children to bring the case before the court. And the last point, we must always remember, strategic litigation is but one of the different ways we bring about change, even for children. And sometimes even when you leave the court with your court order, that's when the real work starts, because you have to implement that, you have to monitor the implementation of it and be accountable on whether that beautiful, nice court order and judgment you got that courts the CRC has amounted to anything for children.
So I don't think it's going to surprise anyone to say that I strongly agree with Karabo with regards to the question of age. And for me, I've put something in the chat, the question of what age this should happen at. And I think the trouble is that, age-specific definitions are unhelpful. We like them in law, this idea of an age cutoff, but that's not how child participation does or should work. And I've put in the text of Article 12.1 of the CRC, which is, of course, what we're using in this project. where we're focused which states that, states parties, right, shall assure to the child who is capable of forming their own views, the right to express those views freely in all matters affecting the child. The views of the child being given due weight in accordance with the age and maturity of the child. And obviously, we're clearly not pretending lawyers or states parties, but that point about, in principle, having, about having this, children who are capable of having their own, of forming their own views, having that right, and then the weight that that's to be given in terms of the child's age and maturity, that's just common sense. That's good legal representation for children. So I think we're not looking at age-specific definitions. It's not saying you're 4, you don't get to have something to say. You're 8, so you automatically do. Oh, you're 16. Well, at 16, you definitely should. But actually, and one of the things that's been really interesting is some of the research around children, focused on children as rights as child witnesses, our understanding about the way in which children can engage as witnesses or interact in different ways with legal processes in a way to make their views heard. And as Karabo has said, it's not so much about if, but how they express their views and how lawyers take that on board. And certainly that would be the approach that we would expect in, say, a child rights consistent model of CRSL. Just to very quickly turn back to this issue of, Nicolás, this issue of, is strategic litigation different between global north and global south, given the political, legal, and, legal and social challenges and context? Yes. I mean, for me, it's not so much global south and global north, but strategic litigation and the factors affecting it vary from jurisdiction to jurisdiction. I would be very slow to say there's a global south model or a global north model, because if we think about common civil, common civil mixed, that is arguably going, whether a court has a modern constitution or an older constitution, the remedies available under that constitution, that sets the parameters, I think, for strategic litigation far more than whether it's a global north or global south. But I agree with you strongly that attitudes towards strategic litigation, both on the part of advocates, but also judges and also duty bearers who have to give effect to it, they vary intensely, not just in terms of jurisdiction, but they also vary in terms of issue. And the fact is there may be real openness to the outputs of strategic litigation or strategic litigation efforts in front of courts, or positive response to courts' decisions with regards to some in some areas that you simply won't have in other areas that are more contested, perhaps more resource intensive. And that, for instance, is why you talk about systemic or structural remedies. That's a very important aspect. But what I would say is, I think the other thing I wanted to flag, and I'm sort of using your comments as a springboard, is that just because a country is wealthy or has perhaps a stronger welfare system does not mean that there are not systemic and structural issues that have implications for a wide range of different institutions and resource allocation and decision making about resources. Those issues still arise. So what I would say is it's easier for us to look at what works and doesn't work in terms of strategic litigation, not in terms of global north, global south, but the particular legal and political context, not just with regards to where the case is being brought, but around the issue that is the subject of the case. I mean, Karabo may add to that, or she may disagree with it strongly, but that would be my response.
Would you like to add to that, Karabo?
No, I think Aoife is right. It's correct that you can never say this is the way it goes. The issue to issue thing is a very big one, because you may have a court being very receptive on, even the court being receptive on an issue, but come the next time with a controversial issue that affects children directly, you see some conservatism and all that. So I agree with her.
Thank you so much. You were both referring to the managing of expectations. I think that is absolutely a clear message today. I still wonder whose responsibility that is. Obviously, it's a responsibility, I think, of those involved in a strategic litigation. Yet you also see, for example, quite recently, that the Committee on the Rights of the Child in the climate case decided to write a letter to the young people involved, clearly not to demotivate them, and to say, listen, the reason why you brought the case is important and we want you to pursue it. But nevertheless, the outcome of this particular decision may be disappointing. I found it extremely interesting that the Committee on the Rights of the Child has done that. And we see it at the national level also happening, that courts are trying to find a way to make their judgments, decisions more child-friendly, so to say. I don't like the word, but I'm using it nevertheless now. So what is your take on that? Because you could have a discussion about who is there to manage expectations, and how can you as a lawyer also make sure that also the decision maker becomes part of that? Do you have any suggestions there?
Can I come in there? I think that what you raised there is very important, and I think all of this is part of a broader notion of bringing children's rights to bear in the justice context, whether it's litigation, whether it's adjudication. And I think there's definitely a role for the courts to ensure that whether courts or international bodies, to make sure that their outputs and decisions are explained to children, okay, and that they are clear to children. I think the Committee on the Rights of the Child had an additional element there where it didn't wish to demotivate children. And I think that was to do with the particular political, and I would say political context, where climate justice is a very important issue, and the committee was making a decision that was going to be highly criticised and very disappointed the children in question. I'm not sure, it isn't the committee's job to manage children's expectations. If lawyers are engaging with children and they're taking cases on their behalf, ultimately, and they are treating children as clients. If you have clients, you manage their expectations. And just because you're dealing with children doesn't mean you hide the tough bits or you gloss over it. And it's easy to excuse that to yourself when dealing with children. I mean, it is in our interactions with children generally, we can kind of cut corners to say, oh, I'm softening or I'm protecting them or it's too complicated. But actually to do so is unacceptable as a legal professional, leaving aside the child rights perspective, I think. But I think it's a very positive trend that we see greater engagement with children in the context of, child-friendly judgments and, for instance, the work that's being done by colleagues such as, Helen Stalford and Catherine Hollingsworth around that area has been particularly important and helpful in guiding to judges and judicial decision makers working in that space.
Karabo, anything from your side on this?
Yes, so quickly, I agree totally with Aoife, and I think also the judges learn through how we package their case. Hence my example about a judge who 10 years ago did not want to, was worried about the maturity of children, and now totally opposite, and now has written a short judgment about how important it was for her to hear this little girl who's in the middle of a custody battle. So that clearly talks to change. The video I showed you, I can tell you we cried with the children, the learners, because we had to along the way tell them about the case. The main one is falling apart in this way. We still need to pursue the bit about your protection and all that, and that required us to go to see them almost once a week, and they are like 2 hours from where we are, but we had to go and sit and be updating because the case was moving so fast. And you have to do that. You have to inform your client, you have to tell them the hard bits, and if they need to cry, sometimes you cry with them, because it was had a racially charged case with a lot of, our history of our country. It was not easy at all. I tried to even stay away from it, but we had to engage with that and go through that process. So if I mention this in a presentation, people must not undermine what it takes to actually legally represent children in litigation. It's not everybody's cup of tea. You can't just say, I've been doing criminal law for 30 years. Tomorrow, I'm a child rights lawyer. It's very, very important. And those are the people who will struggle with managing expectations. For us, it does become part of your second nature to actually think about that when you're strategizing. And when judges send cases to us, we think about how will we deal with this child? How will we explain why we're in the case? Why the judge wants this? And along the way, what the problems are. Yeah, so I will just say that.
Yeah. And just because you're a child lawyer doesn't mean you have a great grasp of children's rights. I would finish on that point as well. There's often a confusion of those two areas of expertise, and they're not the same thing, and they're certainly not the same thing necessarily in terms of practice.
Well, I couldn't agree more. Thank you so much, Aoife. Thank you so much, Karabo. We are, in my country at least, it's 6 o'clock now. And that means that we have to wrap up. But I will not do that without thanking you again, also on behalf of the Center for Constitutional Studies and Nicolás Espejo and Leiden Law School. It was an absolute pleasure to have you with us. Of course, we would have loved to continue the conversation because there's so much to be learned, there's so much to be said and exchanged. So I strongly encourage everyone to take a look at the exciting Advancing Child Rights Strategic Litigation project that Professor Nolan was talking about, and the Center for Child Law is joining also in that effort. I also encourage you to look at the groundbreaking work of the Center for Child Law in South Africa, with again really global meaning. So if you want to learn more, these speakers are the ones to talk to. So thank you so much to all the listeners and participants. Thank you for joining us again, and we look forward to seeing you during our next webinar. So please stay connected, and we look forward to seeing you again soon. Thank you again, everyone.
Thank you very much.
Thank you.